Sheikha Al Thani and other, again, Sheikha Aisha Mohammed, Ali, Abdullah Al Thani and others.
Mr. Mufti, good morning. Just bringing up the papers. Yes.
As the board will have seen, the appeal concerns a very short point of statutory construction. There's probably much between learned friend and myself that is common ground, but I was going to start by looking at the law of succession and how it treats movables and immovables. It makes a distinction between movables and immovables. In relation to immovables, succession is governed by the lex situs, where the asset in question is located. In relation to movables, succession is governed by the lex domicilii of the deceased, where the asset in question is located is an irrelevance. And that distinction appears to recognise that where something cannot be moved, it will always be subject to the laws and jurisdiction of its location. And in those circumstances, those laws should also govern succession to that thing. Where the thing can be moved into any number of other jurisdictions and becomes subject to the laws and courts of those other jurisdictions, then a different default law needs to apply. And it's in those circumstances that the lex domicilii governs. You can see that principle identified in Freak and Carberry, which you will find at Division 10, tab 9, and the relevant passage is at page 458 of the bundle.
458.
Sorry, 458.
Yes, we don't have tabs or bundles, we just have electronic page numbers. So
I'll just give you the page number.
That'll save you.
Thank you very much. Yes, so it's page 458 is the relevant passage. And talking about the relevant rules, you can see what is said there by Lord Selborne. It's not by any special law of England, but by the deference which, for the sake of international community...
Where this is two-thirds of the way down the page.
Two-thirds of the way down, sorry, yes.
I see.
Thank you. It's not by any special law of England, but by the deference which, for the sake of international comity, the law of England pays to the law of the civilised world generally. Domicile is allowed in this country to have the same influence as in other countries in determining the succession of movable estate. But the maxim of the law of the civilised world is mobilia sequenter personam, and is founded on the nature of things. Where mobilia are in places other than that of the person to whom they belong, their accidental situs is disregarded and they're held to go with the person. But land whether held for a chattel interest or held for a freehold interest, is in nature, as a matter of fact, immovable and not movable. The doctrine is inapplicable to it. And so whether something is an immovable or immovable is the next issue, and that's determined by the lex situs of the thing in question. So if the thing in question is in the BVI, it's the law of the BVI that resolves the question. The distinction between...
What's the authority for that proposition?
The authority of that proposition is the Verhot, which we have at page 352, and you can see at the beginning of Mr. Justice Russell's judgment.
Yeah, so it was conceded there, wasn't it?
It was conceded, and I don't think there's any issue between learned from myself.
It seems rather odd, though, because normally the classification of something is for the law of the forum, isn't it? This sends you on a sort of, first of all, you use your local forum law to decide where something is situated,
Yes.
And then you use that law to decide whether it's movable or immovable. And then that leads you on to another law. I mean, I don't know why you don't just go straight in with the question of whether it's movable or immovable.
I mean, I suppose the question needs to be resolved by a system of law, and it does appear that lex situs is the system of law that has been identified, and it appears to have been accepted that that was the appropriate law, certainly in relation to this decision.
So as far as you're aware, that concession is just based on a wide-ranging acceptance that that's the way you do it?
Yes.
Anyway, it leads to the same thing in this case. Forum and citus.
I think it does, exactly, yes.
There is a question of enforceability. You would need to enforce in the jurisdiction of the immovable whatever order a foreign court made.
Of course, yes.
So that it may be connected with that the lex situs is regarded as the proper law.
Yes, I mean, essentially in terms of enforcement, it's always going to be the law of the forum. It's always going to be the forum that dictates.
Yeah.
I think the next point to note is that the distinction between movable and immovable assets is not answered by reference to whether the asset is personal property. There's an extract from Halsbury we have at page 1194. That defines personal property at paragraph 801.
So, 1194.
Page 1194 of the bundle.
Yes. Oh, yes.
Which is the extract from Halsbury, and it's the first sentence of paragraph 801 I was just going to draw your attention to. Personal property or personalty may be described as comprising all forms of property, movable or immovable, corporeal or incorporeal, other than freehold estates and interests in land. And so that recognises that personal property may include both movable and immovable property.
When is it relevant then to decide when something is personal property? When might it be relevant?
It might be relevant in terms of identifying whether properties, well, I think it's a sort of default category, isn't it? Because you have realty, which is the converse of personal property, and so essentially this is a catch-all category saying it's not realty. But as I say, that's not answering the question that needs to be considered. And of course, it's tempting to consider the issue by reference to the physical characteristics of the thing, but that's equally not determinative, and it's particularly inapposite to do so where the thing in question is intangible, such as a share in a company, because obviously that has no physical characteristics. The location of shares for purposes of taxation has been considered by the courts on a number of occasions.
Well, surely the Freak and Carberry was saying you do look at the nature of the thing to decide whether it's movable or immovable. So let's say it's tangible property.
Yes.
It doesn't become immovable because there's a law that says you can't take it out of the country, does it?
If
it's the nature of the thing, which is something you can put in your pocket and walk around with.
Well, I think legislation could actually dictate that for the purposes of some legal principle, it is to be treated as if it were immovable.
Oh, well, of course it can say that.
Obviously say that. But in terms of the physical characteristics, I think that what the Carberry case was showing is that it is the nature of the thing where you have something tangible that you look to. But where you have something that's intangible, then you're in a totally artificial world.
Well, then you might say it's inherently movable.
Well, I think the difficulty there is, again, you're looking at the physical characteristics of the asset. If you say it's inherently movable, you're saying it's movable because it has the physical ability to be moved. And so, as I say, when you get to something that's inchoate and intangible, like a share, it's very difficult to say it's either movable or immovable, yet somehow you have to apply the rules of succession.
Are there any examples of intangible, immovable property? I know you say this is one, but apart from this, has there ever been one?
Not what I'm aware of. But as I say, you're in an artificial world, so you're looking at a world created by either legal principle established at common law or by legislation.
So the legal principle would appear to be, from your answer to my lord, that all intangibles are movable, unless there is some specific provision to the contrary.
Well, I think what I was saying to my lord was that the definition of a movable or immovable property by reference to physical characteristics is not really apposite to intangible property. But I obviously do accept that cases have proceeded on the basis that shares are to be treated as movable. But it's obviously not by reference to the physical characteristics of the share.
No.
But do you accept that if it weren't for the provision, the construction of which you rely on, as meaning these are immovable, that shares are generally movable?
Well, I think shares are or have been treated as movable by the courts.
Well, is
But
there a difference
I
between
think
that and my question.
the difference, I think, is that what you are suggesting to me is that they are movable in the sense that, without regard to legislation or authority, they are physically movable. And what I'm suggesting to your ladyship is that that's not the case. You've got to have an artificial analysis in any event, and the artificial analysis is what you're looking at by reference to the
I
legislation.
thought your case was that it's this statutory provision, properly construed, makes these shares immovable.
Yes.
Yes, and but for that statutory provision, they would not be immovable. Is that not your case?
Well, I think what we would say is, but for that statutory provision, you're then forced to look and see what else would govern whether or not they're movable or immovable.
And what is your position on that?
And my position on that is that we accept that authorities have proceeded in the past on the basis that shares are movables, and it's been assumed that shares are movables.
And you're not making a challenge to that today?
I'm not making a challenge to that.
So the answer to Lady Rose's question is, but for the legislation, these shares would be movable.
Yeah. Would be treated as
treated as movable.
I think that's the distinction I'm making. Yes.
There's a page
to the authorities that you say have treated shares as movable. Have we got those in
well, there's
they referred to?
There's the authority referred to by the judge at first instance, which is the Supreme Court of India case, but I hesitate to take to that because it's very complicated. And
But you were saying there are authorities by which the courts have been treating shares as movables. I was just wondering, where is this line of authority?
Well, there's the Indian case I'm referring to,
Yeah.
and they're also treated essentially as movables in the Macmillan decision.
In the bundle, you've included a passage from Dicey on page 1191, which says that logically things should be tangible things, which may be either movable or immovable, and intangible things, but it's common practice to classify all things as being, to include intangible things in movables.
Yes. I think that's where you get to, but it is an assumption being made by the courts, and certainly I haven't come across any authority in which the proposition's actually been analysed. But as I say, I accept that is the principle that, or the policy that has been adopted by the courts.
But a share of a horse or a share of a piece of land, looking at paragraph 23010, may well be actually an intangible thing, but it is treated as immovable because the thing of which it's an intangible interest is itself immovable.
Yes. So, I mean, the rule has sort of fuzzy edges, so to speak, in terms of how you determine whether something is tangible or intangible, and may well depend on the asset in question. But in relation to shares, one of the questions obviously is the situs of shares. And in relation to that aspect, there is a line of authority, the leading case being Brassard and Smith in 1925, that identifies the situs of shares. If I can just take you to that point for a moment. It's at page 430 of the bundle is the relevant paragraph. And essentially this is was a tax case where the situs of the shares identified whether or not there was a tax liability. And so this case was deciding whether or not the shares were cited in Ontario or Nova Scotia. And you can see in the middle of page 430 the court said, and the Chief Baron's judgment, I think, points to the essential element in determining situs in the case of intangible chattels for purposes of probate jurisdiction, as the circumstance that the subjects in question could be effectively dealt with within the jurisdiction. This is, in their lordship's opinion, the true test. Where could the shares be effectively dealt with? The answer in the case of these shares is in Nova Scotia only, and that answer solves the question. So this is a decision, I should have said, of the Privy Council.
Why was there a contest between Ontario and Nova Scotia?
Both jurisdictions were seeking to impose a succession.
Yes, but what connection was there between the company or the shares with either Ontario or Nova Scotia?
The question was. So if I can just.
In their lordships' opinion, the true test, where could the shares be effectively dealt with? The answer is Nova Scotia. So what was the point? Was the register of members in Nova Scotia?
Yes.
I think we see that further up the page.
The question was where the head. I think the question was where the head office was and where the register was. I think.
I see. All right. Okay.
Well, I think they said that it wasn't the head office was not right, but it seems to be change in the register where the shares are registered. That is, in this case, right?
Yes.
Which is helpful because the way shares were dealt with in 1924 is rather different from how they're traded now, which is that you can trade them wherever you are in the world if you have an internet connection.
Yes.
It didn't exist.
Exactly. And in terms of shares, I mean, there are two possibilities. Either you have a registered share, in which case the shares are effectively dealt with in a location where the register is kept. Or you...
In this case, if I remember right, the head office was in Quebec, Montreal.
Yep. That's right.
And there was a provision that you could have you could have a registry office in several provinces.
That's exactly right. Yes. So the register was in a different location, and it was that issue that was being considered.
And so I don't know whether there were. I can't remember whether there were registers in several provinces, but this particular person was domiciled in Halifax, Nova Scotia, and there was a registry there. And that was treated as a place where his shares could effectively be dealt with.
That's right, yes, yes. But as I say, there are essentially two different types of shares, particularly in the BVI. One is a registered share and one is a bearer share. And the International Business Companies Act 1984 essentially created a new regime in the BVI, which was entirely different from the regime that had applied in relation to domestic companies. And one of the key features of the 1984 Act was the ability of international business companies, IBCs, to issue bearer shares. And the thing about bearer shares is they can effectively, so it can be dealt with effectively in any location by the physical transfer of the bearer share certificate. And if you look at section 31 of the 1984 Act, which is at page 1142.
But do they have a physical share certificate then?
In relation to bearer shares, yes. So
That has to be physically handed over.
physically handed over, and that caused a few problems over the years in the BVI in terms of whether or not there had been effective physical handing over of the certificate. But that was the nature of the bearer share, and you can see, as I say, if you look at section 31 of the 1984 Act at page 1142, that a bearer share is transferable by delivery of certificate relating to the share. So if you apply the...
So there's no register as to who owns them if you've got the certificate in your hand.
That's it.
You own it.
That's it, yes. And of course, from a money laundering perspective, that was slightly bad news. And in due course, as you'll see, the BVI Business Companies Act that was incorporated in 2004 basically brought the era of bearer shares to an end. But in terms of the types of shares, you had those two types of shares, and if the common law rule applied, then the situs of the bearer shares would be wherever they happened to be, and the situs of the registered shares would be wherever the register happened to be. And you can see, if you look at page 1141, that section 28(3) of the
28.3, did you?
28(3) at page 1141 of the 1984 Act
Yes.
provided only that a copy of the share register needed to be kept at the registered office of the company. So the actual share register could be kept anywhere else. And of course, the thing about BVI companies is, whilst they're incorporated in the BVI, usually the actual operation of the company is in some other location. And the legislation actually provides that you can't carry on business in the BVI with an international business company, and similarly with a business company under the 2004 Act. So the register inevitably is going to be kept outside the BVI, and the legislation provides for that to happen.
Say that again. In the BVI, you can't carry on business.
An IB company cannot carry on business within the BVI.
Within the BVI.
It is a vehicle for carrying on business outside the BVI.
Yes, which is why it was called an international
Yes,
business
of
company.
course.
Yes.
Yes.
And so, as I say, in relation to the common law, the common law rule, the situs of the shares could have been anywhere. So it's with that in mind, you then come to section 116 of the 1984 Act, which is a provision replicated essentially identically in section 245 of the 2004 Act, with which you are currently considering.
The page number of section 116?
Is 1143. Which provides for the purposes of determining matters related to title and jurisdiction, but not for the purposes of taxation, the situs of the ownership of shares, debt obligations, or other securities of a company incorporated under this ordinance is in the British Virgin Islands.
Where does this phrase, the situs of the ownership of shares, etc., come from? Does that have resonance in any textbook or authority?
That is not something I've managed to establish. The problem has been partly that the record keeping of the BVI is not quite the same as it might be here, and it hasn't been possible to obtain any material that explains the wording of this provision.
But it seems to be a sort of homegrown provision, not rooted in any private international.
That's right. Yes, it doesn't follow anything, for instance, in the English Companies Act.
Well, I don't mean that. I mean just generally in provisions of in private international law.
Yes.
Yeah.
Do you think anything turns on the words of the ownership of the ownership? I mean, are you making any case that it makes a difference whether it's the situs of shares or the situs of the ownership?
In terms of my argument, I'm not saying that it makes any difference, but it is interesting that it is referring to ownership.
Does it make any difference for any purpose, do you think? Or were those words just redundant?
Well, I mean, it's in our respectful submission, this would have had the same effect if it said the situs of shares is the Virgin Islands. But I suppose what it emphasises is the fact that it is considering the question of title and ownership, which is, of course, one of the points that we focus on.
But as I understood it, you were sort of building up from the common law position,
Yes.
which is the situs of the shares, to actually saying, well, this in a sense clarifies what the position is.
Well, what this does it is essentially, it's not clarifying so much as is creating a new proposition, which is that the shares can only be cited in the BVI.
But is it saying that? I mean, isn't it really saying that the law applicable to title is BVI law?
Well, of course, it could have said that.
But I mean,
but what it doesn't do is say that, because what it does is identify the situs
of the ownership.
of the ownership. So
And did that apply both to bearer shares and to registered shares?
yes, because shares here are including both bearer shares and registered
Well,
shares.
I thought there was that BVI decision which went the other way on that. That said that there was because of the provision, because of section 31, that was a sort of carve-out from 116. That's a case referred to, I think, in the judgments below. So the BVI decision is that 116 does not apply to bearer shares. You may well say that's wrong, but that's not an issue which arises today.
There's a decision, yes, but the decision of Justice Ferrara, I think, is the one you're thinking of. Yes.
As a matter of existing BVI law, 116 does not apply to bearer shares, isn't that right?
Well, I think he refers, I think, to the provisions of the 2004 Act, if I remember rightly.
I think he does, but they're the same, aren't they?
But they are essentially the same.
But you said that bearer shares were abolished by the 2004 Act.
They weren't abolished as such. Essentially, what happened with bearer shares was
Couldn't issue any more.
you couldn't issue any more,
Oh, I see.
and you had to have the bearer shares held by a custodian.
Where?
A custodian could be anywhere,
I see.
but he had to be authorised. So he had to be authorised by the Financial Services
But
Authority.
I mean, just to short circuit this, we are not concerned today with bearer shares.
No, we're not.
So we don't have to say whether that decision in the BVI is right or wrong.
On that point, no.
No,
Yeah.
but the fact that there were these bearer shares literally floating around may inform why it was thought necessary to enact Section 116.
Exactly, yes.
Yeah, and another reason would be if they're only required to be a copy of the share register, where there are registered shares at the registered office in the BVI, there could theoretically, I imagine, be more than one register.
You've also got that issue, yes.
Yes, and so if it is right that 116 does not apply to bearer shares, there would be a perfectly sound policy reason for creating for identifying a legal system that would govern title and jurisdiction.
But that's exactly right, and that's exactly our point. But essentially what you're seeing here is the creation of an entirely new type of company that has the ability to issue bearer shares, has the ability to have its register anywhere. And what the BVI legislation sought to do was to ensure that even though those were the factual circumstances, that the relevant law and the relevant court dealing with issues about BVI shares was going to be the BVI court and BVI law. And that is what we say is the purpose of introducing Section 116.
So this
the relevant law to the extent, but only relating to title and jurisdiction.
Yes.
Yes.
So what it's not doing is following a common law, it's creating a new regime, and that reflects the fact that we're dealing with a totally artificial situation.
Could be said to be clarifying it, because it's by no means clear even now whether issues of title to shares are governed by the situs of the shares or the law of incorporation of the company. One sees the division in Macmillan in the Court of Appeal.
Yes. I mean, I think Macmillan, the majority in Macmillan seem to follow what I say is the common law rule.
Which is?
Which is where the shares can be effectively dealt with. I think you have both Lord Justice Staunton effectively saying...
I thought they said it was the law of incorporation.
Lord Justice Auld says it's the law of incorporation.
I thought it was the other way around.
Lord Justice Auld, I think, says it may be the law of it's the law of the situs, which may be the place of incorporation. And Lord Justice Staunton says it's not for everybody to decide that issue. So I think
anyway,
Macmillan doesn't actually.
It is a muddle. It's not clear.
Yes.
It's not clear. It is.
And if you're looking, we have the words, as you said, it's a question of statutory construction. We have the words there. There are no secondary materials to assist us in this regard, and the only other relevant consideration is what on earth would the purpose of this provision be? And presumably the purpose of the provision was to make the use of BVI companies attractive to international business people.
Well, it was partly that, but also I think it was to ensure that BVI law and the jurisdiction of the BVI courts applied to shares.
But why? I mean, yes, I mean, that is what they may be trying to do, that BVI law and BVI courts determine title and jurisdiction, but by reference to the provision.
Yep.
But what do you say was the purpose of doing that?
Well, essentially, partly it may have been the issue my Lady Rose identified, which is the concern that you've got bearer shares floating around the world, and therefore, from the BVI perspective, it's important to show that you have a solid regime, legislation that is firm and clear in terms of jurisdiction and what rules apply in relation to title. And in our respectful submission, it can be seen that essentially what the BVI is doing is making a bit of a jurisdiction grab, if I can put it that way, in terms of ensuring that the BVI court would be the court that would be determining issues about shares.
Well, I don't think you're disagreeing with me that it was seeking to make the BVI more attractive by introducing legislative clarity.
Yes.
To the extent that it did.
Yes.
Yes.
And in terms of that legislative clarity, the question is, does it go beyond simply fixing the question of citus for the purposes of for transfer of shares, and does it also deal with the transmission of shares on death? And if the intention is to ensure that BVI law applies and the jurisdiction of the BVI court applies, then logically one would anticipate that the legislature would seek to cover the position of transmission on death as well. And in our respectful submission, it did that by making the shares movable. Because by saying...
It's requiring everybody to have a will in the BVI if they want to have BVI.
Well, essentially, if you think about it, if you had real property in the BVI, then you'd have to have a will that complied with the BVI requirements to deal with the real property. And essentially what they've done is to equate shares in a BVI company with real property for the purposes...
I thought you said the real and personal distinction was not the distinction that we're looking at.
No, sorry, I was just answering my Lord's point that in terms of what was being done, they were doing something, I think it was almost being suggested was extraordinary. All I'm saying is that if you were looking at it from the perspective of real property, you would obviously assume that you had to comply with the local rules in relation to real property in terms of succession, in terms of what form of will you had to have. And all they've done is to extend that concept to shares in a BVI company.
And if they have so done, Lord Legate's question remains. Does that mean that to transmit on death shares in an international business company, you have to have a BVI will?
Yes.
Yeah,
well, you'd be amazed to learn that if you own shares in a foreign company, that meant that you had to have a will in that place in order to be able to transfer the shares when you died. That would be incredibly intrusive provision.
Well, essentially what you've got is a legislative provision that
would have the opposite effect of making the BVI an attractive place to hold shares, wouldn't it?
Well, essentially it's introducing a safeguard to ensure that where shares are dealt with, including, for instance, bearer shares, they are dealt with in a way that the BVI recognises as appropriate. And obviously the whole purpose of the wills ordinance is to ensure that there's no fraudulent conduct in relation to succession. And those rules are imposed to ensure that the actual will of a testator is what's conveyed in the document.
Yes, but...
So it's providing an additional safeguard.
Getting back to the statutory words, there are three elements. There are three elements to consider, as we've already said. There's the words, there's, as a secondary source, there is secondary materials of which there are none, and then there's taking a view of the statutory purpose. The words do not deem the shares of such companies to be immovable. You're having to read in to the words that provision. Do you accept that?
Well, what you're having to do, I think, is to recognise what the consequence of the citus being fixed is.
How is it a necessary consequence of the fixing of the citus that what is otherwise immovable is deemed an immovable?
Well, essentially what you're doing is prevent... If you come back to my initial proposition, which is that in terms of immovables, what you're looking at is a situation where the asset in question is subject only to the jurisdiction, sorry, because it's located in a particular location, is subject to the laws and jurisdiction of the courts of that location. So that is that's the basic proposition.
I think we're agreed that the shares in all companies have a situs.
Yes.
So is it the consequence of your argument that a deceased must make a will in the place of the situs of shares that he owns?
He must make a will that conforms with the requirements of the situs in this particular case because of this legislation.
But that is, this legislation at most is saying that the situs of the shares in BVI companies is in the BVI.
And that just tells you which law you apply to decide whether they're movable or immovable, because you apply the law of the situs.
Yes.
Yes.
So we know we must apply BVI law to decide whether shares are movable or immovable.
But what you've also done by enacting that provision is to provide that they can't be moved in the artificial world you're creating. They can't be moved out of the...
Is that the nub? You are saying by fixing the situs, they cannot, as a matter of law, be moved. Therefore, you say they are immovable. Is that really what it comes to?
Yes, essentially.
Yes.
Just remind me what it was about the Qatari will that meant it was invalid under BVI.
It wasn't a will. This is obviously a debate we've had before, but essentially what happened in Qatar was that the prince went to the court and made a declaration, and all that was recorded was a statement by the judge as to what he had heard.
Yes.
Yes, but
What
sorry.
requirement in BVI probate law did that fail to comply with?
Well, under BVI probate law, if you make a will, it has to comply with the requirements of 2 signatures and 2 witnesses and so forth. So the Wills Act provides for... so we've got it in the bundle.
I mean, it's common ground, isn't it, that the Qatari declaration did not comply with the Wills Act or ordinance.
Yes. I'm just wondering what exactly it was, because there are some countries where it has to be stamped by a notary or something.
Yes. Sorry.
If this rule applied generally, then there would be a lot of wills around. I mean, the will doesn't have to be made in the BVI.
No.
He could make a will in Qatar, which dealt with these.
Exactly, yes.
Yeah, so when we call something a BVI will, I'm just trying to be clear what we mean by that.
I apologise, what I meant was a will that complied with the requirements of the BVI Wills Act.
Right.
And those are set out in section 7 of the Act, and it's page 1166 of the bundle. So what we are saying is that obviously a will can be made anywhere, but if it is made in relation to BVI shares, it needs to comply with those requirements.
So if I made a will which complied with section 7, but was governed by English law,
yes,
that would be effective in the BVI.
Yes.
To pass any shares that I held.
Exactly. Yes. Yes.
And you said, just to be absolutely clear, that the declaration that went on in this case, was it even in writing?
It was an oral declaration, as they then recorded in the court record by the judge as to what he had heard.
Yes. I mean, I think there's no dispute that the declaration in Qatar, which in the respondent's case governs the transmission of these shares, would not comply with section 7 of the Wills Act.
Yes.
Yeah. And that is because it wasn't it wasn't a document signed by the testator
And wasn't made in writing.
in the presence of the two witnesses.
It wasn't made in writing, yes.
It wasn't made in writing. The judge's record was a record of an oral statement.
Exactly, yes.
But there's no magic about it being in the BVI or not being in the BVI. Any will made anywhere in the world, if it complied with Section 7, would be effective to pass title in what you say are the
Yes.
immovable
Yes,
shares.
yes. And in the same way, if there's real property in the BVI, a will made anywhere, provided it complies with Section 7, could deal with that real property. I think my learned friend takes essentially 4 points, I think, against me. I was going to turn to those. Before I do so, I don't know if I need to take you to the 2004 Act and Section 245 itself. I just realised I've only dealt with 116. The reason for that is that Section 245 is exactly the same terms.
Yes.
The position in relation to bearer shares is, as I said, they have to be held by an authorised custodian. That's Section 70, page 982 of the bundle. I don't think you need to turn that up.
Page?
982.
982. Okay.
The custodian can be anyway, just needs to be authorised. And secondly, that the register can be kept out of a jurisdiction. So as before, you only need to keep a copy of the registered agent. And that's Section 96(1), 1001. So the same situation arises, that the shares under the common law rule could have a citers anywhere. And so what the legislation does is to change the position in relation to the common law.
But section, yes, they don't. So the 2004 Act doesn't ban the creation of bearer shares. It simply requires them to be held by a custodian. Is that the effect of Section 69?
You can't issue further bearer shares. As I say, I don't think you need to be too troubled by
No,
by
but it's just I was wondering, I just glanced when you were mentioning Section 70 at the previous section, which seems to say where a company issues a bearer share, it shan't deliver it to anyone other than the custodian. But anyway, it may not matter.
Well, your lordship may be right in the sense that I suppose you could issue one and then immediately transfer it to a custodian.
But you say there's no purpose in doing.
There's no purpose. There would have been no purpose in doing it. Essentially, what you've done is to remove the floating bearer share.
Yes, the custodian becomes the equivalent of the register. Yes.
Yes.
Yeah. Thank you.
So my learned friend takes 4 points. The first is he says that the provisions, if they were going to deal with shares being immovables, would have said so expressly. And the point we make is that is, when you look at the wording of the legislation, what essentially it does by saying they can't be moved. So the fact doesn't actually use the word immovable. It is not determinative. Secondly, he says that you shouldn't construe the legislation as removing or limiting a fundamental principle. And for that, he refers to the decision of Lord Hoffman in the Morgan Grenfell case. And the relevant proposition there is at page 635 of the bundle. Paragraph 8. The speech of Lord Hoffman, where he says, secondly, the courts will ordinarily construe general words in a statute, although literally capable of having some startling or unreasonable consequence, such as overriding fundamental human rights, as not having been intended to do so. Intention to override such rights must be expressly stated or appear by necessary implication. The position here is that the International Business Companies Act in 1984 was creating an entirely new type of company and providing what rules applied in relation to that new company. And one of those rules addressed the question of situs and fixed that situs in a particular place, thereby rendering the shares immovable.
You're saying there were, really in 1984, there were no pre-existing rules for this kind of company?
Exactly, yes.
Starting with a blank sheet.
It was a blank sheet of paper. There was no fundamental right being abrogated.
But it was a fundamental change to accepted principles of private international law as regards succession.
Well, as regards succession, there was no change, obviously, to the immovable, movable rule.
Well, there is, in the sense that you say this creates shares in these companies as immovable, which would be a radical change from the law as understood generally.
Well, all I would say in relation to that is that the law as understood generally hadn't been articulated or explained by the courts in any previous decision. So I would accept it that as a matter of
I mean,
assumption.
if you go back to Dicey,
Yes.
pre-1980, the last edition before 1984, we wouldn't find, you say, the sort of exposition that appears in Dicey now.
I suspect you probably would find the same exposition.
Right.
Not suggesting
It was the
otherwise.
accepted position.
It would have been the accepted position.
This
but
was,
yes.
isn't that really the respondent's point, that this legislation construed in the way you submit makes a very significant change to the accepted principles of law against which the legislation was enacted? The legislature is taken to know the law as it stands, and if it's going to make a significant change to the law, it will do so clearly and expressly.
Well, as I say, it's creating a new type of company.
Yes, but they're shares. I mean, these are company. Yes, it's a new type of company in some respects. It's got certain incidents, such as it can't do business in BVI and other features. But I mean, it's not a radically different beast from companies as generally understood.
Well, it is radically different in the sense that you've got a provision that is now dealing with situs and fixing situs in a way that's never happened before.
But sorry, go on, have you finished? What's the position with an ordinary BVI company that does business in the BVI? Is there a provision like this in respect of those shares? Because it would be slightly odd to say that shares in an international business company are immovable in the BVI, unless that was the same actually for a BVI company that's doing business in the BVI.
Well, in relation to a company that's doing business in the BVI, there's no equivalent provision identifying fixing situs in the same way.
So if I had shared, so if Mr. Al Thani had shares in a BVI company doing business in the BVI, then the Qatari will would have been effective to pass those.
That would be right, yes, on the basis of the principle we've been discussing, which is that generally the courts have adopted the approach that shares are movables.
And under that legislation, can a BVI company keep its register of members outside the BVI?
Off the top of my head, I'm not sure the answer to that, but I suspect the answer is that it's going to be a provision that says if the share register should be kept at a registered office.
Not a copy, but the share register.
I anticipate, yes. And I think that would be because there would be no anticipation that the company would have, if it's a purely domestic company, would have branches elsewhere and the register be kept at other branches. So
the situs of shares in an ordinary BVI company is always in the BVI, isn't it?
it would always be in the BVI.
But
Yeah.
they're not immovable.
And there wouldn't be, there's no provision fixing them in this way.
No, you don't need it because
Yes.
it's a BVI incorporated company and its register of members must be kept in the BVI.
Yes.
But the situs of the shares is fixed in the BVI, isn't it?
Well, it's not fixed by legislation.
No, but
Yes.
is it not fixed by a combination of those legislative provisions and the general law?
Yes, it is, in the sense that if the register has to be in the BVI,
Yeah.
and the common law says where the register is, and you're not dealing with bearer shares, so the common law says the register is what determines, or the location of register is what determines situs, then yes, that is right. But obviously what you've got here is a different provision that makes a different...
But the fact that the register of members may be kept abroad, outside the BVI, may be an explanation for Section 245.
That and the fact you have bearer shares. But both elements introduce a...
I think bearer shares are a complication which is not an issue on this appeal and has
Yes.
not been the subject of argument.
But your Lordship's right, that if the register is outside the BVI, then obviously the possibility is that the situs of the shares will be outside the BVI, which is a common law rule.
Yeah.
As I say, what the legislation does is to abrogate that rule and say, no, it's got to be the BVI.
Yes, so it applies BVI law to title, notwithstanding where the register is.
Exactly, yes.
But you accept that although the situs of the BVI shares in every BVI company doing business in BVI must be the BVI, because there's no provision equivalent to Section 245, you accept that those shares will still be treated as movable under the ordinary common law rules and therefore capable of being passed down by a will which does not comply with Section 7 of the Wills Act.
If they're movables, it just has to comply with the rules of the domicile.
Yeah.
Yes. So I think you have to, it comes back to the same point, you have to see Section 245 as making a significant difference. My friend then says that the situs is not fixed for all purposes. Well, that's apparent from the wording of the legislation. It's specifically directed towards two ideas, those of jurisdiction and title. And obviously expressly excludes taxation. And the final point he makes is
So what is your answer to that?
So my answer is yes, that's correct, but it's not relevant. It's not a relevant consideration because
You're saying yes, but so what? Because if it covers title, you say it covers transfer and transmission.
Exactly, yes.
Yes.
And then the final point is that the shares are not fixed for all time because the company can cease to be a company governed by the Business Companies Act and become a company incorporated under the laws of another jurisdiction.
Or even under the BVI jurisdiction, but just under the other legislation.
Yes, if you look at section... yeah, exactly, but it would then cease to be a company governed by the Business Companies Act. You can see that from section 3 of the 2004 Act.
What page is that?
Which is page 953. Which is defining company, and obviously the word company is used in section 245. Unless this Act expressly provides otherwise, company means, and unfortunately somebody's gone wrong with the printing of the official copy. So you get the words "but excludes" appearing as part of subsection 1C. I think it should actually be the concluding words of subsection 1.
So the words after the semicolon should be actually in a full out at the bottom.
Exactly, yes. But excludes a dissolved company and a company that is continued as a company incorporated under the law of jurisdiction outside the Virgin Islands in accordance with section 184. So essentially, once you've taken advantage of the provisions of section 184, the company ceases to be a business company under the 2004 Act, and therefore section 245 ceases to apply. And all that's showing is that the artificial regime created by section 245 is limited to companies that are incorporated under the 2004 Act and remain so.
Now, you've dealt with what you say are the four counter-arguments. As I understood it, the central counter-argument is that there's a non sequitur in your reasoning. That is, we clearly have a rule of law laying down where the situs of the shares is, and that solves what might be regarded as uncertainty in how that would apply at common law. But that then is a completely separate conceptual point from whether or not the shares are movable or are immovable. The two are just not connected.
Well,
and you are therefore, by providing a supposed connection, taking an unwarranted step. Isn't that the main argument against you?
I think that's correct in terms of the argument, yes. And the reason why it's not correct is because by fixing the situs, you're doing more than simply identifying where the shares are. You're preventing them being anywhere else. So you are creating immovability in the same breath as identifying the situs.
I see. So you say you could have had a provision that says that the company's articles have to say whether the situs is in one of three different places, and it's up to you to choose, but you have to choose one. But it doesn't say that, it actually takes that decision for the company. Is that the sort of the point?
It's mandated the situs as being a BVI. And in doing so, it has created an immovable thing.
But surely you're missing out a step in your own argument there, aren't you? It creates situs in the BVI for the purposes of title.
Yes.
That's the important link in your argument, isn't it?
Yeah, exactly.
Title,
Yes.
you say, includes transmission.
Yes, exactly.
Which therefore means that where, for example, you've got disputed wills and you have to decide to whom the shares are transmitted, you say that must be decided according to BVI law.
Yes.
I mean, that's the critical point. It's not because the situs is in BVI, therefore they're immovable. The situs point is limited to title and jurisdiction. It isn't the point of your argument, but it's your third point. You say it covers, when you're dealing with the respondent's 4 points, you say title includes transmission.
Yes. That's right.
It's not just a leap from situs to immovability.
No, you're absolutely right. There's the use of the word title.
That's critical to your argument, isn't it?
Yes. As I said, it's a very simple point in terms
If you, on transmission, you could have exactly the disputes that arose in Macmillan, couldn't you? So supposing the shares in Macmillan had been owned personally by Robert Maxwell rather than by one of his companies, there could have been exactly the issues of priority that arose in Macmillan as to whether priority was enjoyed by Maxwell's executors or by one or more of the 3 banks that had security interests in the shares.
Exactly.
So that would be, on this basis, a matter to be determined by BVI law.
Yes.
But you go one stage further and you say that the entitlement of the executors, rival executors, has to be determined by BVI law, as I understand.
As that's an issue of title, yes.
Yeah, so if there were 2 rival Qatari wills, that you say is a matter of BVI law for the purposes of the transmission of these shares.
If the subject matter of those laws is
Yes.
shares in the BVI company, yes.
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 But you have to make the jump from saying its title includes transmission by succession to then saying, and when you look at the BVI law of succession, it makes this distinction between movables and immovables, and these have to be treated as immovables for the purposes of that law of succession.
Yes, that's a further step, yes.
But, I mean, given my example, why is it necessary to say that they're immovables? I mean, if you're saying that the situs is in the BVI for the purposes of title,
Yes.
and title includes transmission,
Yes.
so you could have 2 disputed wills, yes, executed under non-BVI law.
Yes.
Why do you say you then ignore those 2 disputed wills and say this is immovable? These shares are immovable.
Well, I'm not sure that the existence of the wills changes the position in relation to the shares. As far as the shares are.
Why do disputes as to title, including transmission, make the shares immovable?
What makes the shares immovable is the fact that the legislation has created an artificial world in which the shares cannot be anywhere else.
Well,
Yes, that's the fixing of situs in your reasoning.
Yeah, it's for the purposes of title, though. It's not for all purposes.
Yes.
For the purposes of title.
So for the purposes of any issue that arises in relation to title, and including the example you give, they are to be seen as immovables because of what the legislation does.
But the
That's the
relevance,
leap I can't quite follow.
the relevance of whether they're immovable or movable only arises because of the difference in the Wills Act as to what law BVI applies to the question of the validity of the will. That's why I thought that's why it's important, because your clients need to show that the Qatari will is invalid as regards these shares,
Yes.
so that they pass on an intestacy according to BVI law.
That's right, yes.
Right, but that's why you have to make that jump between this provision and the provisions of the Wills Act. Because if the BVI Wills Act said that a will is valid by the law of the domicile of the testator for all property, then the problem wouldn't arise.
Well, exactly, yes. So essentially you're required to look at what the BVI law is in relation to shares in a BVI company. And that makes the distinction between immovables and movables, and says if it's an immovable, then you have to comply with the requirements of the Wills Act.
Would you accept that that's not a logical necessity? That the law could have fixed the situs of shares for the purposes of title in the BVI without altering the character of those shares as movables? Are you saying that that's an impossible position? It's an illogical impossibility?
Well, it's a matter of construction. You can obviously accept you could construe the provision to say this wasn't intended to include transmission.
If it's including
But
transmission,
if it includes transmission, then we would say that is a position, yes.
you say it's logically impossible to have anything else.
Well, if it includes transmission, then it's then dealing with the question of whether it's movable or immovable.
Why?
Why does, if BVI law governs transmission, but you then have to ask yourself, is the asset movable or immovable?
Yes.
And if you decide that it is movable under BVI law, then the lex domicili will govern the transmission of those shares.
Yes. So you have to form the view that what the provision does by fixing situs is to create.
Yes, and that's why I went back to the sort of threefold analysis in the case of O, in which I had a hand. You look at the words, there's no secondary material, and you ask yourself about the purpose. Why should the BVI create this ambush for shareholders in international business companies of discovering that they can only transmit those shares by wills governed by the Wills Act of the BVI? I mean, it isn't an attractive thing to offer to international business people.
Well, as I say, in our submission, what the legislature was seeking to do was to ensure that BVI law applied to all aspects, including transmission and including the transmission by will of shares. I probably can't take the point much further forward. I think you've probably got most.
No, you've been very. Your point is very clear.
Unless there's anything else I can assist with. Thank you very much.
The board will rise to consider where it is on this matter. Mr. Cumming, we do not need to trouble you. Mr. Moberly-Smith, the board considers that you've said everything that can be said in favour of your client's position, but we have formed a view on this matter. Accordingly, the board thanks counsel for their clear submissions and also for those who have assisted counsel in preparing this appeal. The board will take time to consider what advice it will humbly tender to His Majesty.
My Lord, may I just make one point? I'm very sorry for interjecting like this. Just a point for the record. The version of the BVI Companies Act 2008, which you have in the bundles, is updated as of 2020 it does not take account of the BVI Companies Act Amendment Act 2022, which came into force on the 1st of January 2023, which does do away with bearer shares, and it also, in section 184, deals with, for shorthand, migration of companies abroad or continuation of BVI business companies abroad, introduce another certification hurdle. I just mentioned that. Maybe it's not going to make any difference, but I thought it was better to have flagged it now than not to have done.
But that just affects bearer shares, does it?
Well, so bearer shares are effectively now done away with. On section 184, in order to continue a company incorporated under the Act in another jurisdiction, there's a certification regime. You have to certify that it's in good standing under the Companies Act, etc., etc. There's another requirement that's been introduced in order to get to the process of continuing no longer under this Act. I don't suggest it has any bearing on the determination of this appeal.
No.
I just thought it was best to be entirely accurate.
Thank you very much. Well, the board will take time to consider what advice it will humbly tender to His Majesty.